development rights. To deliberate on this topic, we have with us CA Kuber V. Hundekar. Can I request CA Manjunath Sir, Chairman of Bangalore branch, to kindly escort the speaker onto dais and welcome him with a floral bouquet. Thank you, Chairman Sir. I have privilege in introducing CA Kuber V. Hundekar. CA Kuber V. Hundekar is a chartered accountant and commerce graduate with over 13 years of post-qualification experience in the field of indirect taxation. He is renowned faculty on GST with the Institute of Chartered Accountant of India and has been a speaker at various seminars organized by ICAI branches across the country. Hundekar has played a key role in knowledge developing initiatives, contributing to the background material on GST laws and technical guide on the annual return and GST audit published by ICAI. He also co-authored the frequent asked question on inspection, search, seizure and arrest under GST laws. He released by the Karnataka State Chartered Accountant Association KSCAA. Before establishing his own practice, he gained extensive experience in the indirect taxation domain as a senior manager with SDU, Chartered Accountant Bangalore. He also served as an audit manager at Messrs. SP Nagarath and Company Chartered Accountant. Hundekar is an active member of the professional bodies such as All India Federation on Tax Practitioner and KSCAA. His areas of expertise include GST consultancy, tax planning, and representation before appellate authorities. With this brief introduction, I present before you CA Kuber sir. Over to you, sir.
Good evening, members. Before Kuber sir takes over the dais, I just wanted to briefly say. We all know that from this month onwards, we have 3 hours study circle meeting. Many members were asking why 3 hours, only 2 hours was sufficient. All these years it was only 2 hours, so why 3 hours? It was on request of many members that they are able to, many a times discussion goes on and then the speaker will be presenting it for 1 hour 45 minutes, almost or 2 hours. Will not be having much time for discussing some questions. That is one thing. And then second thing is getting traveling all the way from faraway places to Nagar and then getting only 2 hours. So why don't you think of 3 hours CPE? So that's why we have started a 3 hour CPE from this month onwards. So hope today's study circle would be fantastic. Thank you.
Good evening, everybody. At the outset, I wish all of you belated very happy Chartered Accountants Day. And at the outset, I also want to recognize and extend my deep sense of gratitude to my mentor, Sri S. Venkatraman. I thank Manjunath Sir, Chairman Bangalore Branch, for giving me this opportunity to share my views on today's topic, JDA and KDR related issues under GST. Thank you, Vinoji, for that brief introduction. Whenever there is this real estate discussion, my memory goes back to this one date, which is 26th September 2013. So that was the day when the Honorable Supreme Court, in the case of L&T Limited, pronounced its judgment. The larger bench of Supreme Court pronounced its judgment on that day, and I was a part of the team of Venkat sir. So he called me and he told me that, okay, we will have to write a concept paper on L&T judgment. And not only on L&T judgment, we should go back to the evolution of works contract and the taxability of works contract beginning from first Gannon-Denker leakage. So it was the issue relating to taxability of works contract. It all started with first Gannon-Denker leakage 9 STC 353, wherein the issue was relating to the levy of sales tax on the contract involving construction of building. So the Honorable Supreme Court took cognizance of the constitutional provisions as existing then and held that states are not empowered to levy sales tax, and it was for such reasons the judgment was in favor of the real estate sector, and then the respective state legislatures then amended before amending the provisions, the constitution was amended by virtue of 46th Constitutional Amendment Act. So what happened in first Gannon-Denker case was the Supreme Court held that there is no transfer of property of goods involved in the execution of works contract. The goods, the moment the goods are used or incorporated into the building, the transfer of property takes place in the goods, and that is by way of theory of accretion. So theory of accretion is outside the purview of the state legislature, and therefore transfer of property in goods in the course of execution of works contract is not liable to sales tax is what it was then. So 46th Constitutional Amendment introduced this article 366(29)(a), and it overcame the judgment of the Honorable Supreme Court in first Gannon-Denker case. It is after 46th Constitutional Amendment, there were respective provisions which got inserted in respective state sales tax act, and eventually the transactions involving construction, building, commissioning, erection, installation were subject matter of levy of sales tax. It didn't stop there. It went on again and again. It came again and again. And in the second Gannon-Denker case, again the petitioner was before the Honorable Supreme Court, challenging the levy of sales tax on the value, on the consideration involved in the execution of the contract. So the issue involved therein was the consideration what is received for the purpose of execution of the works contract does not only relate to or involve value of goods, but it also towards labor and other like charges. It also towards element of service provision involved in that, and therefore the entire consideration that is received for the purpose of execution of works contract cannot be a subject matter of sales tax, because sales tax is leviable only on the value of goods that stood transferred in the course of execution of the works contract, and therefore the petitioner was challenging about the levy of sales tax on entire consideration involved in the execution of works contract. The Honorable Supreme Court in second Gannon-Denker case 88 STC 204 held that states are not empowered to levy tax on the element of service, on the element of labor and other like charges. States are only empowered to levy sales tax only on the value of goods transferred in the course of execution of works contract. The Supreme Court held that states should ascertain the value of goods from the books of accounts maintained by the petitioners, maintained by the assessees, and consider only such value of the goods and levy sales tax on that. It further went on to say that if such value is not ascertainable from the books of accounts maintained by the SSE, then the states can formulate or prescribe a formula for each of the works contract or class of works contract, and then ascertain the value liable to sales tax after giving the deduction of labor and other like charges and value involved in the entire value of services involved in the entire consideration. It was in this backdrop, we all know sales tax came out with specific provision to give ad hoc deduction towards labor and other like charges and ascertain or determine the value of goods that were liable to sales tax. It further went on to If further the matter again went before the Supreme Court in the case of Builders Association of India, saying that this add-on reductions towards labor and other like charges is not constitutional and it is invalid. But the Supreme Court held that that is the methodology specified by the state legislatures, and in the event you don't want to claim the ad-hoc reduction, you justify the value of services involved in the execution of works contract so that only the value of goods is liable to sales tax is what was held in that. Thereafter, when the real estate sector started taking up with this JDA was not common then. JDA started very recently off in the fag end of the sales tax regime. So when the JDA, Joint Development Agreements, started picking up, a question arose as to whether the agreement between the landowner and the developer, a tripartite agreement between the landowner, developer and the prospective customer is liable to sales tax or not, or is it leviable to sales tax or not. Because the entire issue involved in these judgments were, the main argument was that it is an immovable property, it is the dominant intention of the contract. The dominant intention of the contract is to get the construction of the building done, and therefore there arises no question of levy of sales tax or levy of service tax. So since the issue was relating to immovable property, the trade or real estate sector was under the argument that this such contract is not liable to either VAT, sales tax or service tax. So when the JDA started picking up in K. Raheja Development Corporation versus State of Karnataka, the matter went again before the Honorable Supreme Court in 141 ST 298. The Honorable Supreme Court in K. Raheja's case clearly and categorically held that the contract between the landowner and the developer is towards works contract services, and works contract services involves transfer of property of goods in the course of execution of a works contract, and therefore the transaction between landowner, developer and the prospective customer can be termed as works contract. But even then, the same Supreme Court in the case of Larsen and Toubro 65 VST 1 again doubted the validity of the judgment in the K. Rahejas, and then again referred the matter back to the larger bench. So essentially in the L&T judgment, the one issue which was not addressed in K. Raheja's case was whether the contract between landowner and developer is works contract and liable to VAT or service tax was the question. So the petitioner's argument was, between the landowner and developer, there will be a contract. That contract may be on area sharing basis or revenue sharing basis, but the transfer of property in goods or the provision of services involved in case of JDAs will take place from the landowner directly to the prospective customer, and there arises no tax liability on the developer was the issue. So the same argument when presented before the Honorable Supreme Court at para 110 of the L&T judgment clearly held that the contract between landowner and the developer is also in the nature of works contract, and the developer will be providing works contract services which involves transfer of property in goods by the developer to the landowner, and therefore the contract between landowner and developer is also subject matter of levy was the conclusion that was reached. When it came to prospective customers, the agreement with the prospective customers, landowner, developer and the prospective customer, tripartite agreement, in such a scenario also there is a provision of service of works contract services, and there is a transfer of property in goods by the developer to the prospective customer, and such transactions or such contracts are also subject matter of levy was the decision of the Honorable Supreme Court in L&T judgment. It is in this manner the law relating to the taxability of works contract has evolved since 1958, first Gen and Hundekar case. But what was works contract then in pre-GST regime? You may take sales tax, you may take value added tax, and now GST. So works contract, what was understood in pre-GST regime is not the same under GST regime. Works contract under pre-GST regime, when we discussed about these many judgments relating to the evolution of the works contract and the taxability of the works contract under pre-GST regime, if you refer the definitions, under the VAT laws and erstwhile sales tax laws, it defined that works contract is an agreement for carrying out building, construction, manufacturing, processing, fabrication, erection, installation of any movable or immovable property. Similarly, Finance Act 1994 also defined the works contract as construction, erection, commissioning, installation, completion of any movable or immovable property. So VAT laws had mention of manufacture, while service tax law that was not specifically mentioning of manufacture because there was a separate levy under Central Excise Act 1944. But VAT was applicable even also if the dealer was undertaking manufacture of goods, and therefore you find a mention of manufacture under VAT laws. But when we come to GST laws, we see this works contract is defined entirely in a different manner, which is applicable only to the building, construction, fabrication, completion, fitting out, improvement, repairs, alteration of only immovable property. So now, under the GST, it is only immovable property. So immovable property, if we go back to the statute and look for the definition of immovable property, we do not find any definition of immovable property. So what is this immovable property is the question first everybody needs to answer. Find out the answer. How we can construe what comprises of immovable property, whether building is an immovable property or whether land is an immovable property or the tower which is erected, mobile tower which is erected is an immovable property or wind turbine generator is an immovable property is the question that we need to understand to before we move on to the taxability of JDA. So when you see immovable property, that phrase has not been defined under GST laws. But interestingly, if you read the various provisions of GST laws, please pay attention that few of the provisions of the GST laws refers to the definition of immovable property, few others refers to the definition of land. Now, land is an immovable property or immovable property is only land is the question what we need to answer. If you see section 2 subsection 119 which defines works contract refers to immovable property. Section 2 subsection 119 works contract refers to immovable property. If you read section 17.5c and 17.5d which is restricting the claim of input tax credit refers to immovable property. 17.5c specifies that works contract services when supplied in connection with the construction of an immovable property. Similarly, 17.5d refers to goods or services or both supplied for construction of an immovable property. Schedule 5A, Schedule 2 Para 5A refers to renting of an immovable property. Section 12 subsection 3 refers to the place of supply of an immovable property. So these are the provisions which refers to immovable property. But if you carefully read other provisions, take for an example, definition of goods defined under section 2 subsection 52 refers to land. Now we see immobile property mentioned in section 2119 which defines works contract, but we see section 2 subsection 52 which refers to land. So now immobile property is land or land is an immobile property. So definition of goods says goods includes land. Goods refers to land. Definition of goods refers to land, and goods is defined to include growing crops, grass and things attached to land which will be seeded before the supply. When you refer section 17 subsection 3, it also refers to land. 17 subsection 3 specifically specifies that the value of land in case of a contract between the parties should be considered as a value of exempt supplies, Section 17 subsection 3 refers to land, and in the similar manner, if you go back to Schedule 2, Para 2, it refers to land and not immovable property. Schedule 2 Para 2 states that any lease, tenancy, easement, license to occupy land is a supply of services. So when we read all these provisions, we come across these two words used differently in various provisions. This itself means immovable property is not immovable property and land are two distinctively referred in the various provisions of the GST law. So therefore, GST law recognizes that the immovable property is different from land. Both the terms immovable property or land are not defined under the provisions of GST laws. Therefore, it becomes an imperative for us to refer to the allied laws. So what are those allied laws where this immovable property is defined is what we need to understand. To start with, if you see, immovable property is defined under Section 3 of Transfer of Property Act, which means that immovable property does not include standing timber, growing crops or grass. So immovable property, if you go back to allied laws, if we see the definition of immovable property, to understand the implications of various provisions of the GST law, where it has made a mention of immovable property, if you go back, if we refer to the definition of immovable property in Transfer of Property Act, it reads as does not include standing timber, growing crops or grass. Transfer of Property Act definition is not clear. What is immovable property we don't know, but it only says does not include. So it is defining immovable property in a negative manner. So therefore this definition is not clear. Then to find out what is immovable property and what constitutes immovable property, we can refer to other allied laws where the immovable property has been defined, which is Registration Act 1908. So Section 2 subsection 6 of Registration Act defines immovable property includes land, buildings, hereditary allowances, right to ways, lights, ferries, fisheries or any other benefit to arise out of land and things attached to the earth or permanently fastened to anything which is attached to the earth but not standing timber, growing crops nor grass. So this is the definition of immovable property under Registration Act 1908. There is this General Clauses Act which also defines immovable property shall include land, benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. So these are few of the definitions which are available for us to refer. If you see all these definitions, specifically Transfer of Property Act, it says it does not include standing timber, growing crops or grass. Similarly, coming back to the definition of GST, where Section 2 subsection 52 defines goods. Goods is defined to include growing crops, grass and things attached to the land which are agreed to be seeded before supply. So one thing that is, if you refer this definition, Transfer of Property Act is defined in a negative manner. So even under the provisions of, even under the issues relating to the Transfer of Property Act, the definition of immovable property under Registration Act and also under the General Clauses Act have been referred. Since we discussed that, okay, it is defined in a negative manner. Most importantly, attention is drawn to Article 367 of the Constitution, which specifically states that the provisions of General Clauses Act shall be made applicable to interpret the articles of Constitution. So the definition of immovable property under the General Clauses Act can be referred to understand what is immovable property. So once we read this definition, we can understand what is land. So the definition is clear, it is land. So it is land, benefits to arise out of land. So what is benefits to arise out of land? Immovable property, land. Okay, we understand what is immovable property, it is land. What do we mean by benefits arising out of the land? is the question. If you also read the definition, under the Registration Act, it says rights to ways, lights, ferries, fisheries are also immovable property. So land we can understand. What are rights to ways, lights, ferries, fisheries is the question to understand, as to understand the implications of GST laws on immovable property. Although such rights are defined to be an immovable property, rights to ways, rights to fisheries, such immovable property are intangible in nature. So land we can understand, it is tangible, we can see land is available on records, title, conveyance deeds, documents relating to ownership of land, all these specify what is land, what is the area of land. So land is an tangible immovable property. But other than land, if you see the definition, rights to ways, lights, ferries, fisheries, all these rights are intangible in nature. So it is not necessary that immovable property, wherever the GST law is referring to immovable property, it is not necessary that it should be tangible. Even an intangible things like rights arising out of the immovable property, which are intangible in nature, would also qualify as an immovable property. To understand further what are the benefits to arise out of land, let's keep this discussion as an interactive. Any questions you can ask me any point in time, or you can stop me any point in time if you have anything to seek any clarification. So what is this benefits to arise out of land? What does this particular phrase means, which has been used in these definitions? To understand the transaction and the implications under JDA, so we should know, okay, benefits to arise out of land, what does this benefits to arise out of land actually mean? So we take few illustrations and examples. Consider an example where a person owns an agricultural land, he gives such land to another person with the right to go and take that crops while retaining the ownership. I have an agricultural land, I am giving it to another person who can use that land, grow the crops and take away those crops is the transaction. So here if you see transfer of right to grow, which is getting transferred from one person to another person, is the right in present associated with that immovable property, and growing crops and taking away those crops is the right in future. So right in present to give land is the object of the contract and not the right in future, and the right in present which is transferred, which is right to grow, is a benefit arising out of land. So this is one illustration. Another illustration, consider one example, mining rights. So where one company owns the land and that company gives another company mining rights, that is the other company which mines the minerals is the benefit arising out of land, and the company B will take away those mined minerals. So right to mine is the right in present, whereas the mining yield are the future benefits. So the same thing if you superimpose on the JDA transactions, irrevocable power of attorney along with interest in land could be for the benefits to arise in future out of such land, and therefore could qualify as an immovable property. Now, consider another example where there is a contract with the government to cut the trees and take away the timber. Is it a contract involving lease, or is it a contract involving sale of timber? Such issues have arisen, were existing then in pre-GST regime laws, and also where the Honorable High Courts and Supreme Courts have held that the essence of the contract is what has to be seen, whether if it is for lease or whether if such contract is for severing the timber and taking away that timber. Considering all those judgments, when the contract is to take away the timber, it is the benefits arising out of land, and therefore In many judgments it has been heard that it cannot be qualified as it will not qualify as a sale of it will not qualify as a transaction involving lease of property, it is the sale of goods. We often come across when we read the definition, when we try to understand what is the benefits arising out of land, we often come across this one particular phrase which says that profit appender. Profit appender. So we generally read this. What does this phrase profit appender means is the question. So profit appender is the right to enter another person's land and extract or take away the natural produce or resources. For example, right to draw water from a river or a lake or a well located in another person's land. It is the benefit arising out of that particular immovable property. So therefore, that right, if I give it to someone else, will qualify as an immovable property. Fishing rights. Right to graze cattle on land belonging to another person is also a right. It is a transaction involving immovable property. Therefore, absolute title to land includes right to use, right to license, right to develop, right to possess, right to exploit. Sale of land is a greater right being absolute. All other rights are also transferred along with such sale. So title of land has multiple rights associated with it. It comes with a bundle of rights. You can use that immovable property is one right. You can possess that immovable property is one right. You can lease that immovable property to another person is another right. So therefore, immovable property does not only comprises of land. Land could always be an immovable property, but immovable property is not always land. Land is one species forming part of the immovable property. Therefore, para 5 schedule 3, if you refer to para 5 schedule 3, para 5 schedule 3, second bullet point, it reads sale of land and subject to clause B of para 5 of schedule 2, sale of building is not liable to GST. So para 5 schedule 3 refers to land and not immovable property. So what happens when there is a transaction involving immovable property? It is not necessary that it is falling under schedule 3 of the GST Act. Only that is exempt under schedule 3 is the transaction involving transfer of title in land, and therefore a view can be taken that a transaction involving transfer of immovable property or the right in an immovable property getting transferred to another person may not form part of this, will not qualify as an exemption under para 5 to schedule 3. We know that whenever there is an exemption entry, that exemption entry should be strictly interpreted. We cannot add any words into that. We cannot change any words. We cannot read the words to give a different meaning. We know that strict interpretation needs to be applied. We have numerous judgments which says that the exemption entry should be read in giving the strict literal interpretation. The recent one is Mother Superior Adoration Convent, where the Honorable Supreme Court held that strict interpretation is what is permissible for the purpose of claiming any exemption. Therefore, it can be understood that land under in Schedule 3, Para 5, and not immovable property, and land alone, and immovable property cannot be construed as to be falling under, will qualify under Schedule 5 of Schedule 3. So, and therefore there is a view that intangible property cannot be land. It is for such reasons Para 2 of Schedule 2 specify that intangible immovable property for lease, tenancy, easement, license to occupy land is supply of services. Now we also see this particular entry in Schedule 2. So what does this lease, tenancy, easement, license to occupy land? What is the difference between lease and tenancy? What is the difference between lease and tenancy? Friends, these provisions of the GST laws are important to understand the implications of taxes under JDA transactions. So therefore, if you read this Para 2A to Schedule 2, what is the difference between lease? What is lease? What is tenancy? Is the question we need to answer. So lease, it uses lease. How the tenancy is different from lease? Lease, we all know, again not defined under the GST law. To refer to the definition of lease, we have to go back to Transfer of Property Act, section 105. It says, transfer of right to enjoy immobile property for a certain period of time and for a consideration is a lease. So, lease definition says right to enjoy immobile property. So, how is it different from tenancy? How is it different from tenancy? So, what is the difference between lease and tenancy? The word tenancy is derived from the word tenant. The tenant is defined under the respective state rent act, and the person who is taking that immobile property on rental basis is called as a tenant. Tenant, if you see, will also have a right to enjoy the immobile property, and similar to the lease, but tenancy is something which is less formal in nature. Lease extends for a period of about 11 months, 1 year, 5 years, 30 years, 99 years. Tenancy will be very informal for about shorter period of time, 1 or 2 months. If I use a land belonging to another person and I tell the person who is my neighbor, I use his space for about 1 month or 2 months for parking my vehicle, and I will pay the consideration. This is a contract of tenancy. This is a contract of tenancy. So lease will be for a fixed period of time, tenancy will be very informal and for a shorter period of time. Landowner lets out the land to be used for vehicle parking for 2 months for a consideration is tenancy. So this is the difference between lease and tenancy. Now it doesn't stop there itself, lease and tenancy. Further, the para 2A of schedule 2 further refers to easement. So what is easement? What is easement? Easement is again not defined under the GST law. While the GST law refers to easement, easement is not defined under the GST law. To understand the meaning of the easement, one has to refer to section 4 of the Indian Easements Act. So what is easement? Easement is again a right. Easement is again a right which the owner or occupier of certain land possesses. So owner, I am the owner of land, I have that easement right is what I can say. For what? For what this easement right is the question. I am using that right for the beneficial enjoyment of that property. For the beneficial enjoyment of that property, I can do or continue to do something. I can prevent or continue to prevent something being done in or upon or in respect of certain other land, not my own. Not my own. So I am a owner of the land. I am the owner of land. I have this right arising out of that land. Easement is a right associated with that land. Such right is not arising out of the own land. So that easement is nowhere connected to my own land. Such right is termed as right for beneficial enjoyment. Such right is connected with the land adjacent to the own land. So what happens? Take for an example, right to way. Consider an example, I have 10 acres of land which is adjacent to a highway. First portion A, I sell it to another person with a condition that 4 acres I sell it to another person with the condition that you should give me access my 6 acres of land. That permission what the buyer gives is the permission which is known as easement. So if I pay a consideration for using his land to access my land is an easement, and such an easement is a supply of services under GST. So what does this mean? There should be a dominant heritage where my own land is called as a dominant heritage. There should be a servient heritage. That means servient heritage is not arising out of my own land, it is arising out of the land belonging to some other person. There should be 2 different owners. One, I am the owner. The other, someone else is the owner. and must be owned by separate persons. Right attaches to land. It is not a personal right, runs with the land. If I want an access right of way to access my property is an easement. If I have one small house in 30 by 40 site. Right next to my site, there is this 50 by 80. The owner is constructing the property. The owner is constructing the property in such a way that the upcoming property is blocking light, is blocking air, and blocking the passage of light and air, and therefore I enjoy that easement right and restrict the other person to say that you cannot construct this wall which blocks which blocks the passage of light and air to my property is an easement right. So this is how the easement is understood in terms of Easement Acts, and the same definition is should be made applicable to the provisions of GST laws. Similarly, right to water, right of drainage, passing through others' land, all these are easements. If I pay the consideration to obtain that easement, is a transaction involving supply of services, and therefore such consideration would be a subject matter of levy under GST laws. We saw lease, tenancy, easement. Now there is another word, license to occupy land. So how this license is different from lease? What is this license? What is this license? Again, the GST law does not define about what is the license, what is the definition of license, is missing under the GST laws. To understand this, the definition of license, we should again go back to Easements Act 1882, where under section 52 it says, where one person grants to another a right to do something upon the immovable property of the grantor. Where I am the owner, I give a right to another person to do something upon the immovable property owned by me, I am being the grantor. So the person whom I will be giving is the grantee. In the absence of such a right conveyed by me, license conveyed by me, it would be unlawful to do such something upon the immovable property belonging to others. Such a right does not amount to an easement or an interest in the property. So how this license and lease can be distinguished or differentiated under the provisions of GST laws is the question. In license, there is no legal interest involved. There is no legal interest involved. If I give a license, you start ಮಾಡೋದಾ? Can we start? I'm sorry, it's an untoward incident. Yeah, we are discussing about license and lease. So we are discussing about the difference between license and lease. So lease is a transfer of interest in property, right to enjoy the property, but whereas license is generally there will not be any interest in land. If you also see possession, permitted use is permitted use, only for what purpose it is meant to be used, only for that purpose the land should be used in the case of license. But in case of lease, it is an exclusive possession. So whether it is transferable license, you cannot transfer. If I give license to another person, only such person should use that land only for the specified purpose. But in case of lease, it can be transferred to another person if the lease agreement provides to transfer. If the lease agreement has its subleasing clause. In terms of revocability, license, you can generally revoke it without any restriction. But in case of lease, no, except you cannot revoke the lease agreement except under the terms of the agreement. So the governing law for license is Easements Act, the governing law for lease is Transfer of Property Act. Therefore, looking at this para 2A of Schedule 2, when we also read this particular para 2 in the context of joint development agreements, Joint development agreement also involves transfer of certain rights in the immovable property to the developer, which we generally call it as transfer of development rights. Also the license to occupy land for the purpose of development of the proposed project. It is for such reasons the JDA which does not involve transfer of title in land and merely involves transfer of development rights will not qualify as sale in terms of para 5 of schedule 3. As such, transfer of development rights being termed as supply of services, there is a view that the same is not the one covered under para 5 to schedule 3 of GST laws. So this is about, these are the provisions largely which are made applicable to the transactions involving JDA, and therefore JDA under GST law is construed to transfer the development rights to the developer. So these were a few of the provisions relating to the allied laws. To understand what is lease, what is tenancy, what is easement, license to occupy land, what are services, JDA involves license to occupy land and it is coupled with the interest. Moving on, if you see how the JDAs are generally executed, manner in which JDAs are executed, we have different terms. If you go practically, if you see, the JDAs are executed with the landowner where developer and landowner come together, discuss about the negotiations, discuss about the terms of the contract and then understand the nature of the project which needs to be developed. So there will be this, we see that all the JDAs we see that there will be some negotiation which is made in the term of term sheet. There will be MOU, there will be registered JDA, unregistered JDA, registered GPA, unregistered GPA, supplementary share allocation agreement, conveyance deed. So all these documents are essentially in connection with the joint development agreement. Each of these documents play an important role. The term sheet, what we are seeing in the bullet point number 1, is not an agreement. It is a terms of agreement with the developer where the landowner specifies, it outlines the key terms and conditions agreed upon by the landowner and the developer before executing the JDA. Term sheet generally contains the details of the property, understanding of the parties' proposed project description of the project, whether it is meant for residential, commercial or mixed development, timelines for the development of the project, exclusivity and confidentiality clauses will also be incorporated in the term sheet. It only serves as a reference document for the purpose of executing a valid JDA between the landowner and the developer. So if you ask me whether term sheet is a valid agreement, whether it can be enforced or not, it depends on how the term sheet is worded. If it says that both the parties have agreed that it shall be legally enforceable, then term sheet can be a valid document which can be considered as an agreement to enforce the various clauses in the term sheets. It may also contain few of clauses which are legally enforceable. There are about 10 clauses, only 2 of clauses the landowner and developer agreed that these 2 clauses are alone enforceable, the rest other clauses are not enforceable. Such scenarios are also possible. Term sheet executed, but the landowner fails to execute JDA with the developer. Now, assuming there is a term sheet, there is a discussion which has happened between the landowner and the developer. They have agreed on the details of the project and the landowner has also agreed to part with the land for the purpose of development. But subsequent to term sheet, JDA, the landowner does not execute JDA. In such situation, we can say that term sheet will also qualify as an agreement for the purpose of applicability of GST laws or for the purpose of enforceability. Consider a few illustrations where based on the term sheet, based on the negotiation with the landowner prior to execution of the JDA, if the developer obtains the plan sanction, obtains the approval from the respective authorities, although in the name of the landowner only, in such a situation, without there being a JDA in place, term sheet can be referred to see the GST implications on such term sheet. Whether this term sheet whether registered or not, whether JDA is executed or not, whether it is an agreement between the landowner or the developer is the question. We know that Section 10 of the Indian Contract Act, which is enforceable till today, refers to agreements. What agreements are contracts? So it defines all agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared void. So all agreements are contracts if they are made with a free consent. Term sheet where landowner and developer free consent, landowner has agreed, developer has agreed, there are terms of contract. For a lawful consideration, parting away with the development rights, developer agreeing to construct the building or develop the project, developer agreeing to share the revenue, developer agreeing to share the area with a lawful object, and therefore term sheet can be construed as an agreement. Term sheet is executed. Consider an example where term sheet is executed, non-refundable deposit or refundable deposit has been paid by the developer to the landowner. Landowner has delivered the possession of land. Developer has obtained plan sanction based on the term sheet. Whether in such scenario, GST implications may arise only based on the term sheet without a JDA. So there is no JDA. There is only term sheet. We'll come to JDA after some point in time. There is only term sheet. I have agreed to give you 2 acres of land and you have agreed to construct a residential complex. Whether this term sheet is an agreement, we discussed, it could be construed as an agreement in terms of Section 10 of the Contract Act. There are various judgments where it says, take for an example to draw your attention to one of the judgment in the case of Supreme Court Alcabos, where they have said where the agreement was executed, the agreement remained unsigned by the seller but only signed by the purchaser. The purchaser, based on the agreement, terms of the agreement, has paid the part consideration to the seller. Seller has accepted the part consideration, has acknowledged the acceptance of the part consideration, refused to part away the land or sell the land to the buyer. In such a scenario, in the case of Alcabos, the Supreme Court held that when there is a part performance that has been done by one party and which is also acknowledged by the other selling party, then there is a valid agreement in place, and therefore, such an agreement is an agreement in terms of Section 10 of the Contract Act, and therefore, in the absence of JDA, the term sheet would be referred for the purpose of enforceability, and such term sheet should be considered as valid agreement. However, if the term sheet specifically states that the said documents is not legally binding, now, while landowner and developer sits and negotiates, they may say that it is not specifically binding and every other party is free to independently carry out or take the actions according to their wishes, and it is not legally enforceable. In such a scenario, term sheet can be said to be as not legally enforceable. I have seen the cases where before executing the JDA, there is NOC, there is plan sanction, there is approval given by BDA, there is approval given by BBA in the name of the landowner. 2025 February, all the approvals issued for the development of the project and for the purpose of the commencement of the project. JDA is executed in the month of May. Assume in that case if the JDA is not executed, all those plan sanctions got or obtained by the developer in the part based on the terms agreed with the landowner could be construed as a part performance, and accordingly we can say that there is a transaction that has already taken place between the landowner and the developer. In various cases, you will also see that there will be exclusivity clause. What does this exclusivity clause means? Before the JDA is executed, because it is a process, it is a long-driven process. It may take 6 months, 12 months, or 18 months, depending on the negotiation skills of landowner and the developer. It may go on and on and on, but there will be a term sheet. In the course of executing this JDA prior to the date of JDA, the parties will agree that for For a period of 180 days, neither party shall entertain any offers from third party. Neither party shall enter into an agreement on the lawful object of the term sheet or enter into any negotiations with the third party. And there is a consideration involved. Developer pays 25 lakhs to keep it exclusive, to keep it confidential. Those are the transactions which emanate out of the term sheet, and even if there is no JDA in place, valid JDA in place, such transaction will again be a subject matter of GST as supply of services, because the landowner is agreeing to keep the contract or the negotiation secretly without disclosing it to the third party. So these are the few of the issues which arises out of term sheets, and it is not necessary that term sheet should always result in JDA. Any document which gives which can be considered as an evidence for the purpose of ascertaining or determining the transaction of supply could be taken on record to say that okay, there exists a valid JDA in place. Because I have seen the cases for RERA there is one JDA, I have seen the cases for other authorities there is one JDA, and in terms between landowner and developer there is a different sort of understanding, and the landowner imposes many conditions. I am willing to give away this piece of land provided you give me an access to the land which belongs to me, which is just behind this. All these conditions are there. All these conditions in itself will qualify as each and every individual supply, and accordingly it becomes very much relevant for us to understand not only JDA but also the terms of the contract to identify whether there arises any other supply other than development rights or construction services in touch between the landowner and the developer. So in that context we took up this example. Now coming back to this JDA, before when there is an execution of JDA, whether registered or not registered, registered JDA, not unregistered JDA, whether JDA can be unregistered, whether there can be a JDA without paying stamp duty, whether there can be a JDA without remittance of registration fee. Friends, if you refer to this, see, registration requirements is under Registration Act 1908. So registration requirements, Section 17(1) and Section 17(1)B, Section 17(1)C specify this particular condition that all the instruments which create or declare or assign or limit or extinguish any right, title or interest in any movable property, the value of which exceeds rupees 100 must be registered. It is 100 because this act was enacted in 1908. So it says any instruments which create or declare or assign or limit or extinguish any right, title or interest in any immovable property is the instrument which needs to be registered under Registration Act 1908. The time limit is specified under the same statute, which is 4 months. Which is 4 months from the date of execution of the instrument. Such the instrument should be registered. We have recently seen in various social media that there was this one judgment which came every now and then popping up, where it was saying that okay, Supreme Court has said if the instrument is not registered, then it is not a valid document for the purpose of conveying a title in the immovable property. Very recently, that was in the case of Manur Fatima Imran versus Vishweshwara Infrastructure Private Limited. That judgment was pronounced on May 7, 2025. In that judgment, the Honorable Supreme Court has taken into cognizance the facts of the case. The agreement of sale was executed in 1982. The agreement of sale executed in 1982 was approached. The parties approached the registering authority in 2006 to register such instrument. The registration was denied, and subsequently when the parties went before the Supreme Court categorically held that it was an instrument which needs a mandatory or statutory registration, and therefore in the absence of registration within 4 months from the date of execution, there arises no transfer of title or giving away the possession of the immovable property, and therefore the instrument which remains unregistered is not a valid instrument, is what the High Court has said. Therefore, JDA which transfers the development right in immovable property, registration is must. So JDA under Registration Act, registration is must, and it is mandatory for taking the registration. Only registered JDA are valid and unregistered JDA are invalid. Non-registration of JDA would have severe consequences in terms of Section 49 of Registration Act. What happens if JDA is not registered? Developer cannot enforce property rights and development rights. Such instrument is not admissible as an evidence of any transaction affecting such property. Title right interest will continue to vest with the landowner. But when we come back to the GST, if you look the provisions of GST, registration of the document has got nothing to do with the provisions of GST. Those are the documents which are those are the provisions which exist under the Allied Laws, Registration Act, Transfer of Property Act, Indian Fund. These are only allied laws to understand the concept of immovable property and their treatment under respective statute. But when it comes to GST law, GST is a tax based on supply transaction. Non-registration of JD will not have any impact under GST law. If the supply is determinable based on the unregistered JDA also, such supply would be liable to GST. Such supply will also be liable to GST. Therefore, term sheets, unregistered JDAs, MOEs or any other document called by whatever name in connection with the JD, whether registered or not, can be relied upon to determine the supply transaction, and accordingly such supply transactions will be subjected to tax. So, even if there is a piece of paper where both the parties have agreed and signed that okay, this 1 acre land is given to you for the purpose of development, if that is admissible as an evidence, and if the supply can be traced, with the facts of the case, then also there arises a levy of GST. Therefore, irrespective of whether the instruments are registered or not, such instruments would be relevant for the purpose of levy of GST, provided the supply is proved, provided the supply is justified. JDA, if executed but not registered, GST is still applicable on transfer of development rights. JDA, if executed and possession not handed over, JD executed but possession not handed over, there is no land is given, so therefore no transfer of development rights exists in that scenario. Therefore, no GST is applicable. Possession of the property is given based on MOU or oral JDA. GST is applicable. Even if there is no agreement, but the parties conduct, there is an oral agreement. Oral agreement, bid to suit, maybe. Oral agreement, I will give away a piece of land, 30-40 site, to construct 2 houses. Even such transactions could also involve transfer of development rights and accordingly would be liable to GST. So we discussed about term sheet, registered JDA, unregistered JDA. Now there is another terminology, GPA, General Power of Attorney. So every joint development agreement, if you see, will also involve execution of general power of attorney. Now there is a JDA. Now there is a JDA, there is a GPA. What is the difference between JDA and GPA? Why? You will always see GPA with JDA. What is the importance of GPA? GPA is a general power of attorney. It is again an instrument. Empowering a specified person to act for and in the name of the person executing it. A general power of attorney is a legal document by which a person called as principal authorizes another person called as an agent or attorney to act on their behalf in a broad range of matters. This is as per Power of Attorneys Act. So what happens in JDA? There is a transfer of right to develop. That transfer of right to develop is not sufficient because the developer also needs that license to manage the property, to enter the property, to apply for building permits, to submit applications, returns and various reports before the RERA authorities, to appear before the BD authorities, to get the NOCs from various authorities. For such functions, GPA will be given. And specifically when it comes to JD, development of residential sites or commercial projects, you will see that the GPA will also have the right to market the units, right to enter into an agreement for sale with the prospective customers, right to collect the money on behalf of the landowner, these are the functions what generally general power of attorneys will specify. So generally JDA will involve, you all know, transfer of development rights. I told you GPA will be for giving, appointing a person to act on behalf of the landowner. Now JDA plus GPA, transfer of development rights. GPA is giving an interest in that land to occupy the land, permission to construct the land. It is coupled with the interest. So what happens when the GPA, by way of executing the joint general power of attorney, there arises an agency between the landowner and the developer. When the landowner conveys the development rights by JDA, developer obtains interest in such immovable property meant for joint development by virtue of such GPA. So when there is an agency, what happens? Okay, consider an example. There is a JDA, the landowner, he is 70 years old, executed the JDA, executed the GPA. Project was supposed to be completed in 4 years, but after execution within 1 year, the landowner is no more. In that case, what happens to developer? Whether the death of the landowner will have any impact on JDA, because he was the landowner, he was having valid title, all the rights vested with the landowner. Now by virtue of JDA he has given away the development right. What happens to the developer and the development activities which is being undertaken in that particular land? Because the landowner is no more existing. What happens in such case? Legal heirs will take away Succession Act. So Indian Succession Act will take care of legal heirs. So legal heirs will come in the shoes of the landowner. But legal heirs can revoke that JDA. On what basis?
If they have GPA,
Who should have a GPA?
the nominee or the
Legal heirs. GPA is already given to the developer. GPA is already given to the developer.
Sir, whether GPA is valid or not, once the landowner is died, whether GPA is valid, because the relationship between the landowner and developer is the agent and the principal.
Correct, sir. So in that scenario, you are saying even after the death of the landowner, the transaction still exists and the legal heirs cannot revoke that JDA or revoke that GPA. What is your answer? Or they can call it off.
No, GPA has no validity.
No validity.
Yes, sir.
Sir, you cannot say that. GPA is...
Sir, the relationship between the landowner and developer is agent and principal.
Agreed.
So once the landowner is no more, it has no value.
Oh, you are saying it cannot be considered as valid.
Yes, sir.
So
Legal heirs has to execute another.
So it automatically stands revoked.
I think.
It automatically stands revoked. Is that your answer, sir?
Yes, sir.
Anybody else? Is it possible? If that happens, then all the projects in Bangalore
No,
will...
I am talking about only GPA, not about JDA.
JDA, because JDA is also signed by landowner, sir.
Signed by landowner, but power of attorney, the relationship between the landowner and developer is agent and principal.
But if you see GPA, sir, it will recitals will always refer to JDA. Recitals will always refer to JDA and it says that, okay, this agreement, this power of attorney is coupled with JDA and JDA executed and so date, registered with so date, as page number, book so and so before the registering authority. In that case, because you cannot see GPA in distinct with JDA, these two documents are executed together, on the same day it will be executed.
But something like this will be mentioned in JDA, no? If something like this happens in future, then this is what.
Assuming JDA is silent. Assuming JDA is silent, because force majeure, all these clauses are there. But what happens? What is the legal safety or security for the developer?
The legal head should have a freshly they can go with the revised JDA.
But by that time, out of 10 floors, he has already constructed. Civil is already done, sir.
No, what I am saying is in the line with the earlier JDA and the GPA, on the same line basis, the new legal head can give the validity to ratify the.
There is why this question is relevant, because these are the common practical issues and scenarios which we come across. What happens if you see JDA and the general power of attorney? General power of attorney is giving away the interest in that land, while JDA is giving away the rights in such land. When there is an agency coupled with an interest, so here, in case of GPA, landowner is giving away the interest to the developer while GPA. So there is a principal and agent relationship that comes into existence. Therefore, Section 202 of Indian Contract Act is what is applicable. So if you go back and read this Section 202 of Indian Contract Act, that specifies an illustration which says that even after the death, the JDA and GP executed by the landowner cannot be revoked by the legal heirs or by anybody else. So what does the Section 202 of the Indian Contract Act says? Where agent here in this case is developer, has an interest in subject matter, has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of express contract, be terminated to the prejudice of such interest. So there should be a written agreement. Even consider an example, even if the landowner wants to go back and wants to give the property to some new developer, he cannot revoke that agreement by himself unless the existing developer gives the consent to revoke. So, even in case of death of the landowner, my view is that the JDA and the GPA which was executed then will continue to exist, and the legal heirs will come in the place of landowner and continue to claim the benefit arising out of that JDA. So these are the practical issues. So I thought, okay, let me take this one issue so that, because Section 202 is very clear. It is a principal and agency relationship that is existing. When we were discussing about GPA, general power of attorney. So this particular issue of general power of attorney came before the Supreme Court. So what happens in general power of attorney? Sir, it is not, general power of attorney is not only executed in case of JDA. General power of attorney can be executed in various other scenarios. I have a property, I can give general power of attorney to my friend. I have to say that, okay, find out a person who can take this on lease. I have a property, I can give general power of attorney to my brother. I'll ask him to go and obtain some NOCs or permissions that is required, whether to construct or renovate or all these things, to manage the property, to collect the rent, to identify the tenant, to be a party to the lease agreement. Sir, possible these things are happening, practically happening, no sir. You will see these GPAs where the owner of the property is appointing an agent to do certain activities on his behalf. Owner will be sitting in US, agent will be managing the property, will be identifying the tenant. All these things are happening now also, and the power of attorney holder, agent, signing the agreement on behalf of the person who is sitting in US. Possible, no sir? It is happening. So why this GPA? Leave about JDA for a moment, for 5 minutes we will discuss about. When I appoint, when Ram appoints his brother, and Ram appoints his brother to identify the tenant and collect the consideration towards the lease rentals, this GPA, what Ram is giving to his brother, will that involve any supply of service? Will that involve just only giving the general power of attorney or appointing an agent, will it qualify as a service? Any reason, sir? I heard saying no. What is the reason for that?
No consideration.
Related party. His brother is related, no, sir?
Supply.
Huh? Supply. Anything other than goods is service under GST law. No? Sir. Yes, okay. 5 minutes.
Acting on his behalf, he is the owner of whatever.
Correct. So agent is acting on behalf of owner. So by virtue of GPA is giving away the right or interest in such a way that you identify the tenant, collect the consideration, manage the property, pay the property tax, do everything relating to that. I understand he will not get any money from his brother. So there is no consideration. There is only GPA. But because of Schedule 1, because of related party, don't you think that this could be a transaction involving supply of service?
How will you value the property? How will you value that service?
Valuation. Sir, people say that anything under this sky can be valued.
But in this case, valuation will be nil.
Valuation is nil. For that reason, Schedule 1 can be made applicable.
So the same arrangement with the third party will always be some commission or some charge.
Of course. So the same reason can be taken to allege that he is liable to pay GST on the deemed value. So we will value. First you tell me whether it is taxable or not. Valuation will come after some point of time.
Only acting.
Sir?
Acting.
He is only acting. He cannot, sir, without this GPA he cannot act. Even if he is brother also he cannot act.
His right is owner's right only.
Sir? No. Property title is in the name of Ram. So property title is in the name of Ram. So just because his brother is managing, he cannot do it by himself. He needs a legal document for that. He needs a legal document for that to represent before the various authorities, before the tenant, to execute the lease agreement, especially when the lease deed is mandatorily required to be registered.
Yes, for business and further because of business.
Sir, business 2 subsection 17, business means anything, even one-time activity can also qualify as business.
Correct. He is not doing anything, that's it. No, he is acting on his behalf, right?
He is acting on his behalf.
That will be a service.
That's what Madam said. If he was not his brother, if he was his friend or maybe some other agent or real estate property manager, he would have charged some consideration. He would end up paying. So that would be liable to GST. How about in this case? So all the GPA holders in some or the other manner would be supplying some services to the principal. You agree? Whether there is a consideration between unrelated party or if there is no consideration between related party. So this is the issue. GST, if the agent is the related party, what are the consequences is what we were discussing. Because GPA is valid. And because there is a GPA, you cannot deny the transaction between the GPA between the principal and agent. And if it is and the agent is a related party, then there is no escape. Even if there is no consideration, it would be liable to GST. But if you go back to Schedule 1, if you see para 3, which talks about principal and agent. Principal and agent, it refers to only supply of goods. Para 3. It refers to only supply of goods between principal and agent. It doesn't cover supply of services. But Para 2 may cover this particular transaction between principal and agent, where the agent is a related party and there is no consideration, because Para 2 reads supply of goods or services or both between the related person or between the distinct person as specified in section 25 when made in the course of furtherance of business. when made in the course of furtherance of business. So in such a situation, what to do? What to do? My view is that if agent is related person and if there is a supply between agent to the principal, even if there is no consideration, by virtue of this para 2 of Schedule 1, the tax is applicable on the services supplied by the agent to the principal. Sir, any question on this? There is no consideration. I am giving GPA. Father is giving to his son to give the land away, to give away the land, to execute the JDA. So that JDA is valid because it is backed by a proper GPA and there is no consideration and related party. Explanation to section 15 specifically covers principal and agent as a related party. Be about father and son or brother, two brothers. Even the principal and agent is also considered as a related party. So these issues are emerging. This is what we were talking about JDA, but other than JDA, in case of general power of attorney, these issues are emerging, and even in these, in case of general power of attorneys, irrespective of the function what the agent is interested to take on behalf of the principal, there could be a supply of services irrespective of whether there is a consideration or not. So I would suggest each one of you to pay attention to these GPAs other than JDA, even irrespective of there is a GPA executed with JDA or it is a GPA giving away certain other rights to undertake certain other functions may also involve supply of services. Any questions on this? Anybody differs from my point of view?
Sir, the advance ruling is possible.
Sir?
Advance ruling.
Advance ruling? Who is speaking? Sir? You want to go for advance ruling on this issue? Sir, advance ruling, you know, it will always be in favor of the tax office. So generally we don't suggest, we generally don't recommend to file an advance ruling, but yeah, you can go for a legal opinion. If you have given a GPA to your to a person who is related, you can go for a legal opinion. 99% where there is no consideration in case of GPA, in case of related persons, I am saying that okay, it would be taxable. It would be taxable. And this GPA issue is not a new one. The issue relating to GPA came before the Honorable Supreme Court in one of the judgments, Suraj Ram's case, 340 ITR 1. The Honorable Supreme Court has dealt in detail with respect to the matters involving general power of attorney. In general power of attorney, the Supreme Court took a cognizance in the case of Suraj Lands that the general power of attorneys are being executed in the real estate sector, to avoid stamp duty and to invest undisclosed income in real estate sector. These are the wordings of the Honorable Supreme Court. To avoid stamp duty, to invest undisclosed income in real estate sector. Therefore, the issue came up before the Honorable Supreme Court, and the Honorable Supreme Court expressly has stated in that judgment that GPAs are resulting in generation of black money. GPAs in the context of real estate are resulting in generation of black money, growth of land mafia, criminalization of civil disputes. GPAs are being executed where the vendor has imperfect title. I am not having an imperfect title. He is not having an imperfect title. I will execute GPA. So in such situation, the GPAs are getting executed. GPAs are executed for undisclosed wealth, income in immovable property without any public record of the transaction for the purpose to another reason what the Supreme Court took is GPAs are getting executed to avoid the payment of stamp duty and registration charges deliberately. Firstly, Supreme Court said it enables large-scale evasion of income tax, wealth tax, stamp duty and registration fees, thereby denying the benefit of such revenue to the government. Secondly, the transactions of undisclosed investments, black money, are increasing day by day. are increasing day by day. Once the GPA stands executed by the landowner with any other person, it does not convey the title of the goods, is what the Supreme Court has held. In general, when the title is not conveyed to the GPA, generally GPA holders are taking advantage of such GPAs, and by taking help of the muscleman, they are taking away all the benefits without giving a portion or partial benefit even to the landowner, because there is a GPA. GPA is executed in 2000, property is getting sold in 2025 by GPA, taking advantage, blocking the landowners to sell the property because there is a GPA or attorney holder is blocking the restricting the landowners to sell the property, and he is making money by selling the property on behalf of the landowner. That is possible, no sir? That is possible. Once there is GPA, he can sell, because that GPA specifically states that okay, so and so person is appointed as a power of attorney to sell the land on my behalf. So that is possible. So he can sign on behalf of the landowner, and that sale deed is considered as a valid sale deed under the Transfer of Property Act also. So because of these issues that were emerging, the Supreme Court, taking cognizance of various provisions of the Transfer of Property Act, specifically section 54, which states that, which specifies that sale is a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. So sale is the transfer of ownership in exchange for a price. Supreme Court expressly referred to this provision. It went on to refer section 17 of Registration Act. Instruments which create, declare, assign, limit or extinguish any right, title or interest are required to be registered. Further, GPA is not an instrument of transfer in regard to any right, title or interest in any movable property, except in cases where power of attorney is coupled with interest. The Supreme Court said, express in cases where power of attorney is coupled with interest, it is revocable. Any attorney holder may, however, execute a deed of conveyance in exercise of the powers granted under the power of attorney and convey the title on behalf of the grantor. So why this GPA? If you want to give away the land, if you want to sell the land, execute sale deed. So don't use this GPA for the purpose of taking undue advantage of in the real estate sector, is what the Honorable Supreme Court held. He is citing all these muscleman, land mafia, all these things. These have been expressly used in that particular judgment. Please go and read the judgment. You will find they have even used criminalization to the extent muscleman, mafia, land mafia, whatever the facts happen, whatever you see, what is happening outside there, all those situations have been covered in that. But however, in the same judgment, while the Supreme Court said that GPA will not transfer the title in the land, the Supreme Court said that executing GPA is not illegal or unlawful. GPA can be executed. In the same judgment, the Supreme Court also made a mention that landowner can execute a GPA with the developer. That is still valid. GPA executed with JDA is still valid, is what the Supreme Court has said. Therefore, there is a general power of attorney which gives which assigns various functions to the developer, and developer will be acting as an agent on behalf of the landowner in the course of construction. So we discussed about term sheet, MOU, JDAs, registered JD, unregistered JD and GPA. So the conclusion is, therefore all these documents should be seen together to identify the transactions between the landowner and the developer. And it is not only the joint development agreement. You may find existence of some other supplies in the case of term sheet, where you refer to the term sheet. And each of the document executed between the landowner and the developer is with respect to certain rights and obligations, may have certain other agreements which are not apparent on the face of JD, and all such activities are liable to GST. all such activities may be liable to GST. So therefore, careful consideration should be given to the entire set of documents which will be executed between the landowner and the developer in the course of execution of the joint development agreement. Any questions so far? Sir, please.
Let us say GPA was executed in 2000 as you said.
Yeah.
At that point of time land value was say 1 lakh rupees an acre.
Yes, sir.
2025, this person in whose favor the GPA was executed makes a sale deed to third party for say 1 crore rupees. Logically, he was supposed to return that 1 crore to the previous landowner, but he hasn't returned. So, is that 99 lakhs amount to supply of service and is it liable to pay GST on that?
No, the transaction, see, when there is a GPA given to the unrelated party, there will be a consideration between the landowner and the agent.
Assuming there is no consideration.
Sir, here you please pay attention. Who is supplying services in case of GPA?
In whose favor the power of attorney?
Agent will supply services to principal. Agent will supply services to principal. In this case, he has made a money. Instead of selling it for 1 lakh, he has sold it for 1 crore. So there is excess amount. So the GPA would still say that the GPA what has been executed in 2000 will also contain the terms relating to the consideration how it should be disbursed to the principal, in what way he can collect, in what way he can execute. All these things will be well written in the GPA. So GPA terms should be referred to see how much his commission is or how much he can retain, how much he is liable to pay to the landowner. All other matters are of civil in nature. If you ask me GST implications, if for undertaking such of these activities, if the agent is charging commission, then that commission is liable to GST.
He is
No.
not charging commission, he is retaining the entire consideration.
If he is returning entire consideration, then you are saying there is no consideration. I mean, for supply of services. If he is returning entire sale proceeds, retaining. If he is retaining entire, that I think is not sustainable. It is not possible, sir. Because generally, general power
I
cut-off,
said like muzzle man and all, they use muzzle power everything.
those things happen, but GPA generally mention the various terms because based on which each party has to.
Okay, let us say take one more example. Let us say in the original GPA they would have mentioned 2 lakhs as the consideration. And after 25 years this person goes and sell it to third party and he gets 1 crore. In that scenario?
In that scenario also. So all these terms and conditions, while I appoint the agent, I'll also write down the terms of contract there. In the sense what the agent is supposed to do, how much he is entitled to claim, if the sale consideration is say for example 1 lakh, how much he is liable to pay to the landowner. All these things will be well written in the GPA and he cannot run away from the terms of the GPA. See, generally how it happens is, there will be a time limit that will be fixed, sir. That will be valid for about 1 year. He has to find a purchaser for that property. So it cannot, this one example we took just to...
But say like sir, many of the developers in Bangalore, what I have seen, 1 or 2 cases, let's say they would have taken some farmers' land, since it's not convertible land, conversion has not yet happened, so they frame a GPA first. Okay, and subsequent to conversion, they themselves make the GPA into sale deed by going themselves on it. They don't call the farmer. Then how does this work out?
No, in that case what happens is the developer or the person who has obtained that GP or GD or whatever document, he would have taken all these consensus in terms of written term, in written terms he would have taken all the consensus from the farmer. He would have said that any document relating to the sale of this property or units arising out of this project, coming out of this project will be sold by the developer as a GPA holder. If you write it and give it to him and that GPA is registered, and stamp duty is also paid, then that is valid. He can represent on behalf of the farmer to part away with the land owned by the farmer. But what happens in that case, there cannot be a transfer of title, because even though there is a GPA, the owner of the property should come and he has to give, he has to mention, he will be a part of that sale deed as a consenting party. Otherwise it is not possible. See, in the recitals only they will mention that there was this land of 50 acres that was given to this developer for development of plot, and he was also given the GPA. The GPA terms were this, and this plot plan sanction was this. All the details would be mentioned. Then they would mention that okay, he is also entered. There is a GPA to given to the developer to sell the land, and that GPA, when there is a consent given, he can represent, but he should also be a party to that sale deed or party to that conveyance deed to convey the title in the land. Because who can convey the title? The person who has the title can convey. GPA holder is only having the right to market and identify the customer.
But if the original GPA itself states that once this land is converted from agricultural land to a non-agricultural land,
Then the moment it gets converted, then there is a transfer of property in land.
so it becomes automatic.
On that day, if the landowner executes the conveyance deed, then thereafter the developer can sell by himself in his own name. See what the agreement says: on the conversion of agricultural land into non-agricultural land or upon the development of the plots, then there is a transfer of title. That is only an agreement for sale till then. Till the project is completed, it is only an agreement for sale. Once the agreement is completed, once the
land is
agreement,
converted.
once the project is completed, once the land is converted, that agreement for sale should get converted to conveyance deed. There should be a fresh document executed between the landowner and the developer. That's what storage land case says. Unless there is a conveyance deed or sale deed between the owner of the land and the developer or any other customer, then there is no transfer of title in the land.
But in the GPA, can't the owner give the right to?
There is only a right.
So that's right to sell that.
So title is different than right. That's what
right to
right
sell
is.
that property in the GPA can't it be?
He has that right to sell, but to convey the title, the owner should come. That's how it is. You see JDAs and you see the agreements executed by the developer with the prospective customer. There will be landowner also be the party to that contract. There will be landowner, developer, and prospective customer. All three people come together. Then they will execute agreement for sale. Once the project is completed, once they want to convey the title in that immobile property or residential unit or apartment, then they will execute sale deed by developer, landowner, and the prospective customer. All three of them come together. Yeah, we can discuss.
Sir, in this case,
Yes, sir.
owner is situated in foreign country. Each time he cannot come and sit in the register office for this.
Then GPA has to mention that, okay, signature of the GPA holder. I think this is more of a civil question. We were discussing about the GST implications. What happens is in case of GPA, there are various terms to the GPA. GPA is giving the, what I can say, will define the scope as to what the agent can do, The example what you are taking now, so that generally happens when it is a related party. Principal and agent are related party.
Can you mention the clause in that even registration you can do? GPA holder can
Yeah, registration can be done. I have seen certain documents, registration can be done, but GPA has to, in case of property development between the landowner and developer, that is not possible. Only in case of related party, that could be a possible, because I have seen certain transactions where they have, where the GPA holder has executed the purchase agreement.
Can he be the assessee on the base on behalf of owner?
Sir?
Can he be the GPA holder, be the assessee? Can he file income tax return on behalf of?
Income tax return, I am not a right person to ask income tax questions, but even the GPA should mention what is the scope, who will pay the income tax, all those things should also be well covered. Therefore, it requires some, what I can say, some sort of attention when it comes to the taxation. So this question is there, but according to me, the person who enters into the lease agreement and who receives the consideration would be liable to pay the income tax. Any person who can address this income tax issue, please, you are free to. Well, I practice in income tax. Any other questions, sir?
So, in many cases, what happens?
Good evening, sir.
So in many cases, what happens is that you have a registered agreement, and then the registered agreement holder will assign the agreement to a third party for a profit. So is there a GST agreement on that if the underlying agreement is for sale of land?
Underlying agreement is for sale of land. It is agreement for sale of land?
Yes. And the assignment happens for profit. So I get into a sale agreement for 100, and then they assign the agreement for 200. So that remaining 100 is the profit.
So you are a person who will be mediating between the landowner and the end customer. Correct?
No.
That's what his question is.
Yes.
So he first has the agreement for sale.
Yes.
And fine. After that, he will identify another customer who will be interested in buying that land. Then there will be a sale deed that will be undertaken by the landowner and the third party customer.
I know. I did the entire consideration. I did 200 because I have already paid 100 to the landowner. Landowner will just come and register. So what happens then? Is it a sale?
It is not a sale of land.
Okay.
It is not a sale of land for the simple reason that there is no transfer of title that is taking place from the landowner to you. You have to prove your title to say that there was a sale of land. There is no title that transfer of title that has taken place.
Okay.
So there is an agreement for sale. The landowner is agreeing to sell to you. The landowner also understands that in the same agreement that you may purchase it by yourself or you may find out another person who may be purchasing it. So this transaction certainly is not a transaction involving sale of land, and you cannot claim that you have executed a transaction involving sale of land.
So the entire 200 rupees are the GST component.
Possible. How the agreement is drafted, that will decide the GST implications on it. Because under GST, it is only sale of land that is exempted. And for selling the land, you should be the legal owner. You can sell only when you are the owner of that particular land, right? You don't have title. The title is still with the landowner. The title is still with the landowner. So you are only mediating between the landowner and the end customer by virtue of that agreement for sale. So there is no transfer of title by landowner to you at the first place, so that you can transfer the title, same title to the
What
end
if the
customer.
agreement gave you possessory right of the land?
That's exactly is the service. That's exactly is the service. If there is no title vesting
So
with
the
you,
agreement gave you possessory right, right? As on the date of agreement, the possession is with the registered agreement holder.
possessory right. Yeah, so that's the reason. When there is no sale of land, when there is only a right that is made available to you, that right is a service under the goods and service tax law.
Because under income tax, possessory right also is as good as purchase.
I don't think so.
For section 54 deduction, if you made an agreement with possession,
Okay.
then it allows you within that date, that
Possible. But under GST, there should be a transfer of title in land. There should be a sale of land. And none of your agreement, if the agreement between the landowner and you if it is not conveying a title to you, you cannot claim that exemption under Schedule 3.
But like you said, assignment is not liable for GST. So will this same not hold good for his example?
We will discuss that, sir. That is an interesting judgment. That's one of the beautiful judgments. We will discuss that. I was coming to that. In the meantime, any other questions so that we can.
Actually, the same questions. You are saying that this is the service. If there is no transfer of the title, there is no conveyance deed, there is only the agreement to sell, and the person of the GPA holder, he just having the possession of the land, and he has searched for another customer. He has second sale. He has made the second sale.
No, only one sale, sir.
No, sale means he had the right, but ultimately to avoid the registration cost, instead of getting registration, he kept the possession with himself and then he sold it to another customer. And so whether he is supposed to pay this GST, suppose if he has purchased the rights in the land, he can in future sell to any third person. Suppose for 1 crore rupees.
Sir, under GST, only if it is a sale of land,
Understood?
only that is exempt.
But if
you
suppose
get the right,
if he has acquired the right
If
the
he has-
land to sell it in the future to any other person.
That is service.
So who will pay the GST at what amount?
Who is supplying services to whom should be understood.
No, means landowner given the possession right against the consideration of 1 crore to the GPA holder has given the right that he can sell the property to any person in the future.
So the consideration, the entire consideration, the landowner is entitled to receive.
He has received landowner. He has received the 1 CR.
Whatever, you may give it in advance or you may give it after selling the land also. The timing of the advance will not determine.
Only the thing is they have not conveyed, they have not did any conveyance deed. They have just entered into the agreement to sell. They have given the right of possessions. They have given the right that he can sell to any other person also. He can execute all the things. Consideration landowner received from the GPA holder, who has taken the possession rights and also has the right to sell the property. Landowner work is, so far as the consideration is concerned, landowner consideration is paid.
You have paid. Okay, understood.
So only the person who is right now having the right in the land to sell it to the third person. So the whole amount, suppose he has paid already to the landowner. Now
consider 1 lakh. He has paid to the landowner.
So
now you are selling it for 2 lakhs.
So selling it happening in the future.
Correct, agreed. In the future it will be sold at 2 lakhs.
Whatever amount. So
consider an example.
Suppose whenever it will be sold.
With regard to this question, there is a 2 leg of transactions which is happening. So the first thing is that between the developer or the landowner and the third party who is the purchaser, the first purchaser which is happening. Okay, there is a contractual obligations during the course of the project or else during the course of the project only. Okay.
Yeah.
So in the agreement itself only it has been mentioned the party, the first party or the second party where the purchaser includes the assigns also. The second leg of transaction happens when it's my right whether I need to get registered in my name or else it's in the person who I am assigning it. Okay, it's a third person who is coming in between and I am getting into a contractual obligation with him, not directly with the landowner or the developer to the fourth person. Okay.
Understood, sir.
I have discharged my liability to the landowner and the second leg, whatever the transactions is happening between me and the fourth person.
It's not between you and the fourth person or third person. It's not between you and third person. Because you have only the right. You have only the right. You don't have title in the land.
I don't have title.
Yeah. So for that reason, the transaction between you may be a party to that sale deed, you may be a party to that conveyance deed along with the landowner because landowner should be a party to that as a nominee.
I execute the assignment deed saying that instead of me, you register in his name. I have already discharged my liability towards you, towards the purchase of land. Okay, my contractual obligation towards landowner, whatever I am supposed to pay to him, I have already discharged. The second thing is that if I make a profit out of it, okay, that leads to capital gains.
Sir, assignment is something different than what we are discussing. Assignment is where the right is assigned to someone else. Right is assigned to someone else. In your example, you have the right. You have got the right. You don't have title in that land. You don't have title in that. You have only right. You call it by whatever, right to sell or right to occupy, right to call it by whatever.
My right.
Or possessive right to possess, all that you call it. What is that? Is that a transaction involving sale of land? Answer is no. Answer is no.
So it's a virtual sale. I can say it's a virtual sale. Because I have a right towards the client.
There is nothing called as virtual sale. I am telling you. Why? Because sale of land, there should be a document. There should be an instrument. There should be an instrument for sale of land, and only instrument can convey the title in the land by the landowner to the purchaser. So, in your case, what is happening? The first agreement what you have made with the landowner, that is not conveying the title. That is not conveying the title. The second agreement what you are executing with the purchaser, that is conveying the title. How the title is getting conveyed? It is by the landowner to the end customer, and you are only facilitating, you are only mediating this particular transaction between the landowner and the purchaser. So therefore, when the question arises on you, the first question is, were you the landowner? The answer is no. So in such a situation, the transaction what you are taking place on account of the GPA, what you have executed with the landowner, may be subject matter of GST.
Sir, sorry, Sorry to interrupt you. Sir, there was a wonderful insights about the definitions what we have been through as of now. So can you please take...
There are three elements, sir. There are three elements. When it comes to immovable property, one is title.
Correct.
The one is title. The other is right. Right, what we discussed as of now. The other is interest. So title is ownership. Title is ownership. When we say that right, you may have right to develop, you may have right to possess, you may have right to enjoy, you may have some other right to sell, like what we get in while the execution of GPA. Third is interest.
Yeah, sorry sir. I was just coming to the point that if you can give more insights about the TDR, that will be great enough.
Yeah, we are going to TDR now, Rahita construction.
Because with the allotment of the time, what is left now? So
We'll quickly finish these few judgments. Yes,
sir. Thank you.
But you are clear with the, you got the answer?
Yes.
But sir,
Thank you.
one condition, if there is a GST liability, suppose in the case of this one, GPA persons, the sales happen subsequently.
Yeah.
Instead of suppose 1 crore, suppose in the future he is selling to 2 crore. So you are saying that there is no direct sale between the GPA, it is the sale happening in future.
Yes.
But in the first transaction, which the GPA holder paid the amount to the landowner, that amount GST.
That is for obtaining right.
So who will pay the GST?
That is for obtaining right. So if you purchase the right, landowner has got that money for agreement to sell. See, whatever agreement says, I am willing to sell this. Agreement for sale. So he has appointed you. You will be the purchaser, or you also has got the right to find out some other customer in your place. So it is towards the consideration for land when it comes to the landowner. But when it comes to you, when you are getting the money for the sale that takes place between the landowner and the end customer, then it is not a sale of land. So that was a limited point here. So we'll discuss this, sir. I think we'll get more clarity.
Only the thing is that if there is any GST liability in this post entire transaction, who will have to be at the button?
The person who is mediating, who has that right to possess.
And what amount?
Entire. Consideration is entire, because there is what is he doing? How much money he is receiving? How much money he is receiving? He is receiving entire consideration 2 crores in his example.
But he will get input tax credit, no? For the amount.
There is no input tax credit because the landowner, the consideration is for sale of land. So there is an issue, sir. That's the reason I took this example of general power of attorney. These things are coming into the limelight, and we may have certain cases on these things.
So just to add some perspective, I just want to ask, in reference to these questions itself, if payment of stamp duty doesn't have any impact?
It doesn't have any impact. It doesn't have any impact because GST is transaction-based system, supply-based system. So even if there is a document, whether registered or not, it may be a non-compliance under Registration Act, or it may be a non-compliance under Karnataka Stamp Act. But if tax office is able to prove that there is a supply between the landowner or agent or the developer, then that evidence itself is sufficient for them to establish the supply and impose the tax on it.
Sir, good evening. Sorry.
Sir.
I just wanted to ask, in these cases, all of these cases, what is the GST implication on part performance contract under TOPA?
TOPA?
Transfer of Property Act.
Part performance of contract 53A. 53A deals with part performance of contract.
Yes.
53A should be read with specific relief act. So if there is a part performance, if there is, you have executed an agreement with your friend saying that I will be willing to sell this land for 50 lakhs. For 50 lakhs, that agreement for sale is not conveying any title. You are not, in the sense, that agreement for sale is not conveying the title by you to your friend. That is only an agreement. You are agreeing to sell, sir. That's all. You have not yet sold. The sale happens only by executing the conveyance deed.
No, but 53A, what is?
I'll come to that point. So part performance, there is a doctrine called as doctrine of part performance. Now, you have taken from your friend 20 lakhs out of 50 lakhs. So he has he has met the requirement of part performance, and it is a part performance on what he has undertaken because of that agreement for sale. Now what 53A says, you cannot go back and cancel that agreement and deny that sale of land or property to your friend, is what 53A says. Because there is a part performance, and you have to necessarily oblige or sell or part away with the land as per the agreement for sale.
The one that I am talking about, part performance, where the Supreme Courts have held that if the entire consideration is received and the possession is transferred, even if there is no sale deed that has been executed and registered,
exactly,
it is still considered as a sale.
That's exactly I am saying.
But
there is no transfer of title. There is no transfer of title because of 53A.
No, but the Supreme Court has held that there is a transfer of title, right?
Because there is a possession that is given, because by virtue of this part performance by your friend, then you have that possessory right is what it says. But the same judgments what you are referring to have further said that because of that part performance or because of that 53A, because of that agreement for sale, there is no title that is getting transferred from you to your friend. Please read that judgment.
And I think that can be only from income tax.
Only from income. You may have certain questions on income tax, but under Transfer of Property Act, sale deed or conveyance deed is must. It should clearly state that there is a transfer of title in land in exchange of price. In exchange of price. Shall we move on to development rights? Quickly. Sir, there was these two judgments. The first judgment is Rahita Construction Private Limited. Sir, I had this opportunity to review the draft petition first answer along with Venkata sir. I have reviewed that. What was our objection? What was our arguments before the Honorable High Court of Telangana is the development rights agreement or the joint development agreement is essentially for transfer of an immovable property, and right to develop is also an immovable property and would not fall within the scope of GST. Was first point. The second point what we made a mention is JDA creates an agency, and once the agency is created, the entire interest in the land stands transferred to the developer, and the landowner by himself cannot revoke that JDA. Therefore, you should consider this as a sale of immovable property since JDA creates that agency. Neither of the parties after execution of JDA cannot revoke is what we discussed. By virtue of JDA, there is a substantive transfer of development rights. After that, even the landowner, if he chooses to do something with that land, he can't do because there is a JDA and GPA. Importantly, what we said, 4/2018, I hope everybody knows about 4/2018. 4/2018 is ultra vires the constitution. 4/2018, quickly to discuss, I will just 4/2018, it says a registered person who supplies development rights and a registered person who supplies construction service of complex to the landowner is liable to pay GST on the date of completion. This is in essence what this notification says. So what was the argument? So 4/2000 is ultra vires. These arguments were considered. And what the Telangana High Court said is, it is basically based on the various clauses of the Joint Development Agreement. They said this particular transaction of Joint Development Agreement does not involve transfer of property in goods. It does not involve transfer of property in the immovable property, and therefore this will not qualify as a sale in terms of para 5 of Schedule 3 of the GST. So development rights under the judgment of Telangana High Court is still liable to GST. Now Rahita Constructions is before the Supreme Court challenging the verdict of the Telangana High Court. So we are awaiting the judgment of the Supreme Court. So therefore, transfer of development rights can be safely brought within the purview of an outright sale of land. The answer of the Honorable Telangana High Court was no. The similar case, Safal Constructions India Private Limited. Look at the irony in Safal. In Rahita Constructions case, that the Honorable Telangana High Court did not even stayed the recovery of GST. It made a specific mention that the petitioner has to pay the GST by virtue of this JDA. But in Safal construction, the issue was relating to sale of DRCs. DRC is development right certificates. So development right certificate obtained while after the compulsory acquisition of the immobile property, the development right certificates issued by the government authorities, those certificates, if it is sold, the allegation was it is liable to GST. So I have the development right certificate, I can sell it to the developer who can use those development right certificates and increase the FSI, free space index, and of that particular project. He can increase the flows. So the issue was those development right certificates, the allegation was it is liable to GST. The matter is before the Honorable High Court of Gujarat. But interestingly, Honorable High Court of Gujarat has stayed the recovery of GST from the petitioner, Safal Constructions. Gujarat Chamber of Commerce and Industry versus Union of India. We were talking about assignment. This is the judgment of the Honorable High Court of Gujarat on the assignment. So what is this assignment basically? So we spoke about assignment. We were saying we are assigning the property. What is this assignment? We discussed about lease, tenancy, easement. Now there is new, fresh phrase, fresh word, new word that is coming. What is assignment? Assignment is generally understood as transfer of existing rights or benefits by an assigner to the assignee, such that the assignee steps into the shoes of the assigner. To illustrate, if one person is about to receive money from Mr. A is about to receive 10 lakhs from another person, B, Mr. A can assign the right of recovery to Mr. C. So, Mr. A is assigning the right to recover. Now, B cannot say that I cannot pay money to C. So, this is the assignment. So, what happened in the judgment in the case of Gujarat Chamber of Commerce and Industry? Gujarat Chamber of Commerce and Industry was acquiring land and it was developing the land for the purpose of industrial estate and also creating the infrastructure. So there was this Gujarat Industrial Development Corporation. It was getting the land from Gujarat Industrial Development Corporation. Gujarat Chamber of Commerce was developing the plots or property or real estate, industrial estates, and Gujarat Chamber of Commerce was giving it on a lease. To other entities to establish manufacturing facilities. The issue that came up is Gujarat Chamber of Commerce, which was giving this lease for 99 years for a consideration, is liable to GST. First, there is a lease agreement between Gujarat Industrial Development Corporation and Gujarat Chamber of Commerce. First lease agreement. These leasehold assignments, these leasehold rights were assigned to industrial units by Gujarat Chamber of Commerce and Industry. Now there was this notice from the department saying that Gujarat Chamber of Commerce is liable to pay GST. For assigning the leasehold rights to the industrial units. The issue went up to the High Court. There were three parties. First is lessor. Gujarat Chamber of Commerce is lessee. The third party is industrial units or entities which were taking these assigned leasehold assignments from the assigner, which is Gujarat Chamber of Commerce and Industry. First leg of transaction between Gujarat lessor and lessee. It held that it is a lease. That lease is for 99 years. We have an express exemption under 12/2017, and therefore it is not liable to GST, and it is exempt is what was held. But the second leg of transaction, where assignment was taking place, assigner and assigned industrial unit, the Honorable Supreme Court held that transaction involves supply of immovable property, because the entire rights what the assigner lessee got stood transferred to the industrial unit, and there was no benefit that the lessee assigner has retained. That means Gujarat Chamber of Commerce has retained nothing. Instead of he being a lessee, now there is a new person, and this was an assignment. By virtue of getting the new industrial unit into the place, Gujarat Chamber of Commerce and Industry is giving away the leasehold rights as on assignment basis. So therefore, it's a wonderful judgment. Here in this judgment, the Honorable Gujarat High Court has dealt with all the provisions relating to the Transfer of Property Act, Registration Act, General Clauses Act, to some extent Stamp Act also. I would urge you to go back and read. I think all of your doubts will get cleared the moment you read this. But assignment of leasehold rights, finally the Gujarat High Court has held that it is not liable to GST, it is a transaction involving immovable property. So this was about assignment. So that's the reason I was mentioning that okay, assignment, we will come to that issue some time later. There is this another new judgment, Asha R versus Assistant Commissioner. Here in this is the judgment of our Karnataka High Court. Everybody would be knowing it was a allegation relating to the applicability or leviability of GST on the solatium paid to the landowners because of compulsory acquisition. The Honorable High Court held that okay, compulsory acquisition and the solatium maybe could have been termed as a solatium, but that solatium is arising on account of transfer of title in land, and the person, the landowner, does not have any possession of land or even the title of land is given away. Therefore, the solatium paid to the landowner is not liable to GST. It is essentially involving sale of land is what the government has said. So these were about a few of the judgments relating to transfer of development rights and assignments, and we discussed about various other provisions. We have this 4/2018. We discussed about 4/2018. Transfer of development rights by the landowner and the construction services by the developer to the landowner are liable to tax, and it is liable, and such tax needs to be paid at the time the conveyance deed is executed. So it is basically on the date of completion of the project and at the time when the possession is given to the landowner for his share of units. 23/2019 effected certain amendments to 4/2018, stating that the time of supply and development rights supplied as per the said notification would not apply on or after 1st April 2019. So that means time of supply on development rights supplied as per the notification number 4/2018 would not apply on or after 1st April 2019. So 4/2018 for the transactions executed or agreements executed at that point in time is only applicable with respect to the construction services. 4/2019, on 29th March 2019, we have seen many notifications which has changed the manner in which the real estate transactions were being taxed. We had this 3/2019 which got notified, 4/2019 which amended the exemption notification, 5/2019 which amended the reverse charge notification, and there is 6/2019. So 4/2019 was issued to exempt the landowner on supply of development rights subject to the condition that the promoter shall be liable to pay tax on reverse charge basis in case of residential apartment to the extent attributable to residential apartment remaining unbooked on date of completion certificate or occupancy certificate. We all know that development rights 4/2019 is exempt. If I am giving development rights in the land, it is exempt in the hands of the landowner. That is getting taxed, and on reverse charge basis in the hands of the developer. That is being taxed based on the flats remaining unbooked as on the date of completion of the project. 4/2019 provides that the promoter is liable to pay tax under reverse charge mechanism. If you see this 3/2019, 4/2019, 5/2019, all these notifications refers to RERA. If the project is registered under RERA, then these notifications are applicable. If the project is not registered under RERA, none of these notifications are applicable. So, what they use REP, they use RREP. There are definitions which they import from RERA. Specifically, this one second bullet point, section 2 ZN of RERA says development of plots is also a real estate project, and accordingly would be liable to, the developer would be liable to obtain the registration under RERA provisions. So we discussed about para 2A of schedule 2. Supply of development rights by landowner to be considered whether the same applies to a license granted to the developer by the to enter the land for the purpose in terms of the joint development. We discussed this. It could be considered as a license to occupy land, and there could be a right which is being given to the developer by virtue of GBE. First bullet point, whether tax on development rights is applicable where JD is entered before 1st July 2017 and project is in progress in GST period. So in this case, there is a JDA which is executed in pre-GST regime. There is a JDA which is executed in pre-GST regime. Now, the project is completed in GST regime. What are the implications on transfer of development rights? Is the question. So, the point of view here is, when the JDA was executed, the development rights got transferred from the landowner to the developer in pre-GST regime. The transaction took place in pre-GST regime. In pre-GST regime, if you refer to the definition of the service in Finance Act 1994, section 65B44, it was excluding the transaction involving immovable property. So therefore, there is a view that JD executed in pre-GST regime are not liable to GST. Because the development rights were transferred in pre-GST regime and immovable property transactions were outside the ambit of the services as defined under section 65B44. But look at this 142.10. What the department is saying, you might have executed the JDA pre-GST before 1st July 2017, but I have one provision under GST law, section 142 subsection 10. Section 142 subsection 10, which says that same as otherwise provided in this chapter, the goods or services are both supplied on or after the appointed day, in pursuance of a contract entered into prior to the appointed day, shall be liable to tax under the provision of this act. So the department is saying, since it is a spillover project, JD was entered in pre-GST regime, got completed in GST regime, I can invoke 142.10, section 142.10, and there arises a liability in the hands of the developer because the project is completed after 1st April 2019 and the new notifications are applicable. This is the argument what the department is taking. But if you read this provision, it is pursuant to a contract entered prior to the appointed date and the goods stand supplies after appointed date. So, in case of development rights, we discussed that it got transferred on the date of execution of JDA. Therefore, this provision is not applicable. This provision, section 142.10, is not applicable to cover the transactions involving JDA executed in pre-GST regime. So we know that there are area sharing and revenue sharing. So these are the types of joint development. 4/2018 we discussed. There is this explanation we discussed 23/2019. So we discussed that there are only if the projects which are meant for sale and which are liable to be registered under RERA, only to those projects the provisions, the notifications 3/2019, 4, 5, 6/2019 will be made applicable. We'll move on. Residential flats, commercial complex not meant for sale. There is a JDA for development of residential or commercial. The residential or commercial units are not meant for sale. When they are not meant for sale, they are not liable to get registration under RERA, and therefore the taxability of supply of service by the landowner to the developer on forward charge basis. So there are various scenarios. There are scenarios in which the tax is liable to be paid on forward charge mechanism. There are scenarios on under which the tax is liable to be paid on reverse charge basis. If the project is not meant for sale, that means that project is getting developed for the developer and the landowner to retain their share of units, and therefore those notifications which were issued on 29th March are not applicable, and as such, irrespective of the timing of the execution of JDA, the tax is liable to be paid on forward charge basis. Even after 1/10/2019, because we had this, we saw this notification number 23/2019. Development rights would be liable to tax in the hands of the landowner if it is project not meant for sale. Time of supply, JDA entered. Look at the timing, look at the period 1/7/2017 to 24th Jan 2018, because 25th Jan 2018 we got this notification 4/2018. If the JDA was executed between 1/7/2017 to 24th Jan 2018, date on which the development agreement is entered into between the landowner and the developer, if it was executed on 12th of July 2017, the tax liability arises for the month of July 2017. JDA entered between 25th Jan 2018 to 30th September 2019, date on which the constructed complex is handed over by way of possession by the developer to the landowner, because the application of notification number 4/2018 comes into picture. JDA entered after 1st October 2019, the date of entering the agreements. The date of entering agreement, the time of supply would be the date of entering into the agreement, since notification number 4/2018 is ineffective due to insertion of expansion by notification number 23/2019. Valuation, cost of construction. So there is always this issue relating to valuation. So valuation in case of development rights again depends on the time at which the development JDA is executed. If it is executed prior to 1st April 2019, we have to refer to Rule 27, Rule 30, Rule 31 of the GST rules for valuation of the development rights, and accordingly pay the GST. If it is JDA is executed after 1st April 2019, the notification 3/2019, 4/2019 specify the valuation mechanism, and accordingly the valuation mechanisms needs to be adopted to ascertain the taxable value. Therefore, depending on the date of agreement, the valuation methodology should be adopted, and accordingly the tax needs to be discharged. Development rights are classifiable under HSN 9972 and they are liable to tax at the rate of 18%. And are liable to tax at the rate of 18%. Any questions so far on these notifications what we discussed? I was a bit fast because I had to catch up the time.
Notification 4/2019 is saying is shifting time of supply again at the time of entering the JDA.
Notification 4/2018.
No, 2019 you said 4/2018 is reverse.
4/2018 is on the date of completion of the project or giving the possession of the constructed units.
After that the next notification, because that is
4/2019.
4/2019. So as per that, taxability is on entering the JDA, is it?
No, taxability is 4/2019 is applicable to the JDAs executed after 1st April 2019.
Yes.
And such of those JDAs are liable to tax on the date of completion. There is an express provision. Yes, yes, yes.
The JDA has been entered on a 50/50 basis for developing a layout.
Okay.
So the cost of construction is 1 crore rupees. So 50 lakhs is landowner share and 50
When the JDA is executed, so that is the important question.
1st April 2019 onwards.
1st April 2019 onwards. Okay, this is for plotted development.
Yeah, plotted development. So whatever this 50% is pertaining to landowner and 50% to the developer, can the developer claim input tax credit on the 50% value? Because anyway he is charging 18% tax.
This is plotted development executed after 1st April 2019.
Yes.
Plotted development rights are taxable on reverse charge basis. Now there is works contract service that are also taxable. Now your question is?
The 50% cost what I am incurring for the landowner development,
Okay.
can he claim the input tax credit?
You are liable to pay GST, you can claim input tax, 18%. So, let's take a look at development rights residential meant for sale. Residential meant for sale. So in so there are various categories of projects. So we'll pay some attention to the so far we discussed not meant for sale. Now we are discussing not meant for sale. 1/7/2017 to 24/1/2018. Taxable development rights are taxable in the hands of the landowner. In the hands of the landowner, the reverse charge mechanism got notified only with effect from 1st April 2019. JD is executed prior to 1st April 2019 and therefore it is forward charge mechanism. Time of supply, date of which the development agreement is entered into between the landowner and the developer. Because 4/2018 notified on 25/1/2018 became operational with effect from 25/1/2018, 25th Jan 2018. Therefore, any JD executed prior to 25th Jan 2018, the time of supply is the date of executing the JD. Valuation. A view can be taken cost of construction plus an element of gross profit of 10% or guidance value, municipal value of land as on the date of entering into the agreement. Rate of tax applicable is 18%, HSN 9972. JD entered meant for sale 25th Jan 2018 to 31st March 2019. Liability tax under forward charge in the hands of the landowner because JD is executed prior to 1st April 2019. Time of supply, it is the date of completion or transfer of possession in the or the right in the constructed complex by executing conveyance deed. So time of supply, you should refer to the completion date because only after completion of the project you can execute the conveyance deed. Valuation again, cost of construction plus an element of gross profit. Rate of tax applicable is 18%. JD executed after 1st April 2019. Here is the catch. 4/2019 is exempting. So in first two scenarios, landowner was liable to pay tax in forward charge mechanism. In this third scenario, landowner is exempt from payment of GST. Liability arises on the promoter developer on reverse charge basis. Time of supply, we have this notification 6/2019 which specifies that the liability arises on the date of issuance of completion certificate or first occupation of the project. And the tax should be paid in a tax period not later than the tax period in which the date of issuance of completion, not later than the tax period in which the date in which the completion certificate or occupancy certificate is issued. Valuation 3/2019 specifying the valuation. It says value of apartment equal to the total amount charged for similar apartments in the project from the independent buyers less 1/3 value of total amount charged for the apartment may be considered for the purpose of computation of the tax. So we have this mechanism how the TDR is getting liable to GST in the hands of the developer. They have given this formula. So you will have to consider the residential area to be constructed in that land. So you can apply this formula to arrive at the value. The rate of tax that is applicable is 5% because the notification number 4/2019 clearly specifies that if it is affordable, 1% is the rate of tax that is applicable. If it is non-affordable, 5% is the rate of tax that is applicable. Rate of tax again is 18% but restricted to 5% or 1%. TDR applicable. Plotted development, if it is by virtue of JDA, TDR will eventually be there.
But how will you do the competition? Because the competition mechanism only says sale of flat or flats.
In plotted development is largely it is meant for residential.
No, if you go by the previous slide, that exemption calculation was for total carpet area of the residential apartment. So for plotted development, there is no residential apartment.
That's what we said, no? Section 2ZN of RERA includes plot also as real estate project. So this is equally applicable to the development of plots. So that's how it is. It's that complicated.
So can you go to previous slide? Next slide. Somewhere you mentioned the cost plus 10% has to be considered.
That is not meant for sale. That is not meant for sale. So meant for sale, not meant for sale. Meant for sale, RERA registration. Not meant for sale, no RERA registration. Meant for sale, RERA registration plus new notification. Not meant for sale, no RERA registration. No new notifications are applicable. Commercial, we can have a look at the commercial. 1/7/2017 to 31st March 2019 taxability, forward charge, time of supply, date of entering into the JDA, valuation cost plus rate of tax is 18%. JDA entered after 1st April 2019. See, this exemption is given. This exemption under this notification number 13/2017 specifies that the person, the developer or the promoter who is receiving the development tax is liable to pay the tax on reverse charge basis. 5/2019 has effected an amendment to 13/2017. Time of supply 6/2019 in case of commercial meant for sale, and the tax has to be paid in the tax period during which the occupancy certificate is obtained. Valuation mechanism, para number 2A, rate of tax 18%. We will construction by developer to landowner. So we all know construction services provided by the developer to the landowner is also liable to GST. Up to 24th Jan 2018, residential cum commercial composite supply of works contract taxable on cost of construction plus a gross profit of 10%, cost plus basis. Effective 25th Jan 2018, a view can be taken by giving reference to explanation 2A to notification number 11/2017, and accordingly the value can be determined considering the value of apartments sold nearest to the date of JDA. Valuation appears to be very harsh, but yeah, that's how the notification specifies the provisions relating to valuation. We all know about this judgment of the Honorable High Court of Gujarat in Munjal Manish Bhai Bhatt versus Union of India. So here, the High Court has held that 1/3 restriction towards the deduction of land is ultra virus and cannot be restricted at 1/3, and if the value of land is determinable or ascertainable based on the agreement entered between the developer and the prospective customer, that value needs to be considered for the purpose of giving the exemption for land. So this is one judgment. I think it was the judgment was pronounced in 2022. We all know this is before the Honorable Supreme Court. We have to wait and watch what would be the verdict of the Supreme Court. Whether 1/3 will be still considered as good law or bad law, we have to wait and watch. Construction services taxability 6/2019, time of supply, date of completion of the project. Plotted development. So under plotted development, we have these various advance rulings where in some substance I will cover this PPD living spaces, smart spaces, Bhopal Smart City development, appellate authority advance ruling. Deepesh Anil Kumar. What essentially in this advance ruling, what the advance ruling authority has done is, they said developed plot is not same as the barren land. Developed plot is developed with infrastructure, amenities, and it is ready to occupy. Barren land is without any facility. The value that is charged from the customer, even though there is no development charges that has not been collected from the customer, the value or the consideration collected for the plot also includes the charges towards this development. And therefore, in few of the rulings, what the advance ruling authority has held is in Deepesh Anil Kumar and in Bhopal Smart City Development Corporation, even though it is a plotted development, even though if you own the land, when you own the land, you are liable to take the registration under RERA because you are willing to sell the plots before completion, and therefore, if you sell the plot or if you receive the consideration before completion of the project and before you get the completion certificate from the authority, competent authority, then such agreement is also liable to GST. Is what these advance ruling in sum and substance have held that plotted development is also liable to GST. These were the advance rulings which came prior to this clarification 3rd August 2022. Plotted development, while there is some amount of confusion whether it is required to be, whether we have to apply the provisions relating to para B, 5B of Schedule 2 to consider it as a project or not, but the clarification says that if the land is sold after leveling, laying down of drainage lines, etc., is not liable to GST. So land, if it is sold after development, it is not liable to GST. So therefore, a sale of land in a plotted development can be considered as non-GST outward supply based on this ruling.
Will it make difference if it's RERA registered or non-registered?
RERA registered, non-registered, will it make
Some
a
plotted
difference?
development are RERA registered. And in case some of them are not registered under RERA, will that ruling hold?
That's the confusion. The project includes plotted development under RERA. So if you are developing a project for and converting the land into plots, you are liable to obtain the RERA registration. You are liable to obtain the RERA registration if you want to sell the plots in the course of construction or in the course of development. So if you obtain RERA registration, then 3/2004/2005/2019 will be made applicable. Those notification refers to RERA provisions. Project includes plotted developments, and therefore 5B para of Schedule 2 could be made applicable to that. And then say that there is a view that is being taken that okay, even if there is a own land and even the plot is getting transferred, or if you are entering into an agreement for sale of plot before the completion of the project, then also it is liable to GST is what the view is. So in the same manner, these advance ruling authorities in Deepesh, Sunil Kumar, Gopal Smart City have held that even in case of own land, you are liable to pay GST because land, what you are referring to is undeveloped land. Plotted development, what you are referring to is developed plot, and developed plot comes with an amenity. Undeveloped plot may not carry the same consideration what the developed plot has, and therefore, before you complete the project and if you are selling the plot, you are liable to GST is what these rulings have had pronounced. But in this circular, in this circular, it is clarified that land is not liable to GST.
So in case of Kanak AR in 2003, they are clarified that land will not occur.
Godrej. So in Godrej case, what they have held is it is not liable to GST. In Godrej case, it is a own land. In Godrej case, it is a own land. This ruling came after this circular, sir. This Godrej ruling came after this circular. After this circular, these rulings were prior to this circular. So in Godrej, the advance ruling authority held that applicant is not liable to charge GST on sale of plot if the booking of plot, receipt of consideration and agreement for sale is entered after the release certificate. So in the plotted development, there is something called as release certificate. So they will release 40%, they will release second set of 40%, then they will release 20%, then they will issue completion certificate. So first release of 40%, when you relinquish the property in the common area what you have developed, they will release 40%, and after releasing that 40%, if you sell the plot, it is not liable to GST is what it says, bullet number 1. The applicant is not liable to GST on basic infrastructure development charges if the booking of plot is executed prior to the release certificate. The applicant is liable to charge GST on other common amenities and facilities charges if the booking of plot, receipt of consideration and agreement for sale is entered, as well as sale deed is executed after the release certificate. Clear, sir? Clear? Agreement for sale is entered prior to the release certificate and sale deed is executed after receipt of release certificate. The applicant is not liable to charge GST if the booking of plot is executed after receipt of release certificate. In the same way, booking basic infrastructure development charges is also not liable to GST. The applicant is liable to pay GST on other common amenities and facilities charges if the booking of plot and receipt of consideration and agreement for sale is entered prior to the release certificate and the sale deed is executed after the receipt of release certificate. This is in sum and substance what the advance ruling authority in Godrej case has pronounced. So this is about plotted development. There is this TDR. Sir, we discussed everything about TDR. One or two points what I want to bring to your attention is that there were enough number of judgments. This TDR issue is not only started in GST regime, we have seen this TDR issue in pre-GST regime. In fact, we handled the cases where they are alleging that TDR is liable to GST. In pre-GST regime, we saw that okay, it cannot be a service liable to service tax because service definition excludes immovable property. But we have various judgment. Chada Housing Development Corporation, it has been held that TDR is a benefit arising out of the land and must be held as an immovable property. Similarly, in Sadodai Builders Private Limited versus Joint Commissioner, it is held that it is an immovable property, and similarly, Draupadi Devi case, it is being held that it is a transaction involving immovable property. Taxability of TDR is contentious issue and need to see how the courts will interpret the taxation under GST. More importantly, when the Prahita construction case is pending before the Honorable Supreme Court. So this is about TDR. I am now willing to take up the questions if any of the delegates have any questions which.
In your previous slides, you have mentioned the release certificate is a compulsory.
So that the GST is not applicable.
In both the cases.
See, many of the village side and all, they might not be receiving this release certificate. So in that case, how the tax?
Sir, no. In there is one act under Karnataka Land Reforms Act. I think they didn't have to issue this release certificate. It is mandatory. Even if you develop in Chitradurga, they will have to issue release certificate. There is a advance ruling authority also. I mean, judgment of advance ruling authority also. Ruling of advance ruling authority.
Sir, one doubt. Daughter is a non-resident staying in foreign country. Father is a resident in India. Okay, father enters based on GPA with a company rental agreement. Rent is paid to Indian account of daughter. Now GST attract to daughter, and father is related party. He is ensuring all the facilities.
Rent is paid to
daughter.
Daughter. Owner of the property is
daughter.
Daughter. Okay.
Father is doing some facilities like entering agreement, ensuring the rent is being collected. Here for him any GST should be attracted.
Yeah, if it is for a commercial property.
There is a consideration element, that's why I am saying.
No.
And how the valuation comes here.
No. This is a rent, the commercial property is given on rent.
Yeah.
Correct? So he is liable, the daughter is liable to pay GST.
Yeah, she is paying GST.
Okay.
No father element I am saying.
Father is
facilitating some movement, collecting the rent, ensuring those things.
Okay.
Since he is a relative party, no consideration, GST should be attracted. What is the valuation for that?
Now all this time, see what happens is, if he is considered as a supplier, he is supplying it to his daughter. There is no consideration. Of course, they are related party. I am not denying that. If there is, if you say that okay, if it is evidence that okay there is a supply of service, then there arises a tax liability. Valuation is something which we need to see. But supply of service between two persons, whether related or not related, it is liable to GST side. If you have any document to prove that there is no supply, then it's a different matter. If you have a document to prove that there is a supply, then obvious.
Rental agreement is signed on behalf of daughter.
That's okay, no problem.
It says clearly based on GPA and saying on
That's okay, no problem. That should not give rise to any further complications.
Something we need to charge like that. Say something around 5,000.
See, property it again depends on the property. What kind of property? If it is only one small building that he is managing, or if it is a commercial complex, big one, all that has to be seen. But in any case, when he is managing the property, there will be a maintenance or camps that will be done, will be taken care by the third party. They may have some agreement also if it is required to show that okay there is some sort of a consideration that has been collected because of rendering these services, which is subject matter of GST is what we can see. It is ultimately immovable property where it is located. would be the place of supply. There will not be any exemption of any other. Well, this will qualify as an intrastate supply and would be liable to GST. Questions? Yeah, that's all from my end. Before I take a leave, I thank all the members for giving me this opportunity and giving me patience. I thank you, Bangalore Chairman Manjunath sir, and also, of course, Prashant. He was the one who made it to conduct this session. GS Prashant. Thank you, Manjunath sir. Thank you. Thank you one and all. Thank you very much.
Respected member, I would like to inform you that the member who was unwell during the session, we have immediately taken him to hospital and treatment is on. Now he is feeling better and we have also informed to his family member. I stand before you today on behalf of Bangalore branch to express our heartfelt gratitude to CA Kuber sir for sharing his valuable insight during the session on the topic GST issues on joint development agreement and transfer of development rights. Your expertise, your experience and passion for the subject, we have significantly enhanced our understanding and application in our respective fields. We are grateful for your time and effort you have invested in preparing this session, particularly in addressing the GST queries and concerns that many of us face. Thank you once again, sir, for your exceptional presentation and for sharing your expertise with us. We look forward to future interaction and learning from you again. Now I request C.A. Raghav Bansal, Treasurer of Amritsar branch, to kindly come to the dais and hand over a token of memento as a token of gratitude and appreciation to Kuber sir on behalf of Bangalore branch and members present here. Raghav Bansal has travelled all the way from Punjab to Bangalore. Sir, thank you sir. Thank you member, good night.